Federal High Court in Abuja has barred the Central Bank of Nigeria from disbursing further monthly allocations to the Rivers State government, citing alleged constitutional violations by Governor Siminalayi Fubara. In her ruling on Wednesday, Justice Joyce Abdul Malik found that Governor Fubara's presentation of the 2024 budget to a four-member House of Assembly breached constitutional protocol. Justice Abdul Malik highlighted that since January, Rivers State has received and spent allocations based on an illegitimate budget, describing this as a constitutional aberration. The court order further restricts the CBN, the Accountant General of the Federation, the state's accounts at Zenith Bank and Access Bank from releasing any funds to Fubara. The judge contended that the governor's actions ignored constitutional requirements for budget approval by a fully constituted House of Assembly. Delivering his judgment in suit FHC/ABJ/CS/984/2024, Justice Abdul Malik declared that decisions made by the four-member Fubara-backed Assembly were void, referencing prior rulings by the Federal High Court and Court of Appeal that had annulled its authority. Justice Abdul Malik stressed the CBN's responsibility to ensure that state budgets are approved by a constitutionally recognized House of Assembly before releasing funds. Any appropriation bill must pass through the constitutionally recognized House of Assembly, she stated, without which any budget implementation is unlawful. The ruling also held that Fubara's actions violated Section 91 and 96 of the 1999 Constitution and warned that any continued bypassing of legislative processes constituted an affront to the rule of law. The court's decision followed a suit filed by the Rivers State House of Assembly, led by Martin Amehule, challenging the legitimacy of the four-member faction loyal to Fubara. The Amehule-led assembly had earlier declared in July that all state expenditures would be halted until the governor resubmitted his budget to the legislative body. Justice Abdul Malik denied a request to stay the proceedings, dismissing the application as frivolous and vexatious. She also refused to recuse herself from the case, rejecting the defense allegations of bias. Ndamzi, you are a legal practitioner, so I'll start with you. What is your take on this development?
Yes, thank you very much, Choma. My take on the judgment of Justice Joyce Abdul Malik is that it has opened a new jurisprudence again in our system, and has also served as deterrent to people in authority who has vehemently and flagrantly refused to obey court judgments, and thereby, threatening the rule of law in our country. Because any society that does not encourage or uphold the rule of law is bound to fail, no matter who is involved, no matter how highly placed the authority may be. Now, looking at the judgment of the Federal High Court as regards this budget in question, in my view as a lawyer, I will hold that that judgment is in line with constitutional provisions, because Section 96 sub 1 is very clear as to quorum of House of Assembly of a state. The Constitution says there must be 1/3 of members of a House of Assembly present and doing business in that particular day. So when it has to do with budgetary concerns, appropriation bills, the proper quorum for a House of Assembly to sit, look at it, approve it, for the government to sign into law, it has to be the minimum of 1/3. And by Rivers State position, we have 32 houses of assembly constituencies here in Rivers State. One, my learned colleague, has passed, remaining 31. If you look at the proper quorum should be 10 or 11 persons present and doing business on that very day it was sent. And Justice Omotosho, in his judgment, stated it emphatically that the state governor should go back and represent the budget to the Rivers State House of Assembly. The state government vehemently refused that. In fact, it was on air. The governor came up on air and said he wasn't going to obey the judgment of the court. So that is an aberration. It's an aberration when individuals, no matter how highly placed, will put themselves above the laws of the land. When we have that position in our country, then it means nothing lawful will happen. People will just behave like animals, and there will be anarchy, there will be lawlessness everywhere. And I don't think any sane man would want lawlessness to prevail in our system. And also, so many have argued that this judgment will stall the civil servants from receiving their salaries. Yes, when allocation is stopped, it means the state may not have funds at that moment to pay salaries and embark on some project. But the question is here, the question is simple. Must we act on emotions, leaving out what the law says? The law is supreme. If the state government had done the right thing, I don't think we would be where we are today.
All right.
If the state governor had obeyed the court judgment, the first court have said, represent the budget. He refused. The Court of Appeals re-echoed same. He refused. So I wonder.
All right.
And people have mixed up this present judgment of the court with other concerns.
Yes.
So I want to clarify that this judgment is basically on the no appropriation bill in Rivers State.
All right. Talking about your last statement when you said that people have misconstrued this judgment, likening it to other judgments, I want to bring to your attention the concern and argument out there, and that is in reference to the 2004 Supreme Court judgment over the LCDAs that were created by Tinubu when he was the governor of Lagos State, and when Obasanjo was the president. You recall that part of the ruling of the Supreme Court in that judgment was barring the courts, barring the Supreme Court, barred the court from ordering, so stopping the payment of allocation to the local governments. Now, people are saying that, according to the Supreme Court judgment, that the court in this instance now does not have the jurisprudence to, order the Central Bank of Nigeria from stopping payment of allocations to Rivers State government. What is your reaction to that?
Yes, I disagree vehemently with anyone positing that the 2004 judgment of Justice Uwais Idris in the case of Lagos State against Federal Republic of Nigeria. Some have argued that this present judgment of Justice Joyce Abdul Malik will not stand because Supreme Court
had ruled in the past, in 2004.
I disagree with them completely. I disagree with anybody who might throw in that thought.
What are your reasons?
My reasons are this. The facts in issue are different completely. The Lagos issue was basically the then governor created additional unconstitutional local government development areas. So the then President Olusegun Obasanjo, through an executive fiat, stopped the payment of allocations to Lagos State. Allocations meant for local government councils to Lagos State.
Right.
So the court held in that judgment that the federal government does not have the powers to stop lawful allocations meant for states. But in this case, I want to say it to the listening viewers out there that the Rivers State concern, it's a different facts in issue altogether. It is not related with the Lagos 2004 judgment, the Supreme Court 2004 judgment. The Rivers State issue is a question of, there are three legs in this budget issue now. First is presenting a budget to an illegal assembly. I term them illegal in the sense that they do not have the proper quorum to sit and receive that appropriation bill. Secondly, the second leg is that when the dispute arose, the Federal High Court, in its final judgment of Justice James Omotosho, ordered the Rivers State government to represent the budget accordingly as enshrined in section 121 sub 1 of the 1999 Constitution, which simply says that the governor of a state shall cause to be presented to a House of Assembly its expenditure and budgets. Okay? Then if you look at section 122 sub 1, the Constitution says where there is no appropriation bill at the moment, what happens? The Constitution empowered the governor to make withdrawals
for 6 months.
For 6 months. Anything exceeding 6 months is an aberration, is unlawful. Right. In fact, it is not only unlawful, it could be criminal. If at the end of his tenure, a criminal charge can be preferred against him for illegally withdrawing funds that are lawfully restricted. So, people shouldn't act out of emotion because civil servants might be denied of salary for a month or two, but we should look at what is right in the eyes of the people.
All right, Ndamzi. Daniel, what do you have to say to this story?
Yes, let me take it from the last question you asked about the case of the former AG to Lagos State government in person of Osibajo then, the governor of Lagos State, who is now the president of Nigeria. Part of the relief, though cases are not the same, but there were reliefs granted that you could deduce and say, okay, from this particular reliefs granted, it works for this particular case. For example, part of the relief was that can the directive of the president to withdraw allocation to a state, can it stand? And the Supreme Court said, no, that money belongs to the people of Lagos State. The money belongs to the people of Lagos State. Now, bringing same back to the judgment that happened yesterday, which is that allocations meant for River State is stopping at the source from the Central Bank of Nigeria. It is illegal.
All right.
It is illegal. It is an abuse. It's using a sledgehammer on an ant. Okay. The question before the judge was the River State House of Assembly against the governor. It has nothing to do with the CBN because the governor of the state is properly elected. It's not an illegal governor.
Let me.
No, I'm coming. I'm building on. Okay.
Hold on, you still go on. You said it had nothing to do with the CBN. Now, CBN, we are respondents in the matter. because CBN is the institution responsible for disbursing these funds. If CBN was not a respondent in this matter, they will not have their lawyer.
No, you are breaking my line of thought. Hold on. CBN is responsible for disbursing doesn't mean CBN owns the fund.
Go ahead.
We are first talking about ownership.
Of the fund.
Ownership of the fund belongs to River State.
Okay.
And so it is statutory. No one can stop it by the decision of the Supreme Court against Lagos State, against the federal government.
Are they the same issue?
Now I'm coming. The fund, the question first is the fund. It is when the funds come, they will not decide how it should be spent and in what manner should that funds be spent. That is the case in court. That the fund that came into River State, does the governor has a right to spend that fund without a proper constituted House of Assembly? That is the case. It is not about
without a budget, not without a proper constituted House of Assembly.
No.
It's the budget that is the problem.
No, it is not the budget.
What is the problem?
The problem was that the governor presented the budget before an assembly that's not properly constituted. That is the problem. It is not the budget that is the problem. And so whatever that you now put on a foundation that is nullity, everything is nullity.
Was there a court judgment annulling the presentation of the budget?
No, hold on. You see, that was something we have debated here.
Okay.
And I have said it at different fora that I go with the judgment of the Federal High Court saying that the governor of River State should go back and represent that budget. I also align myself with the judgment of the Court of Appeal asking the governor. In fact, the Court of Appeal in itself, the Federal High Court was even mild a bit. The Court of Appeal uses some words against the governor of River State, saying that go back to the Martin Amehule led House of Assembly and represent that budget. That is properly debated. That's an argument that no one you can't fault it until there is a court that reverses that decision. But I'm saying that the judgment that came in from the Federal High Court, probably they have presented all cases before her to say the governor is still going further to spend the money belonging to River State. And I'm saying that the money should come to River State. A money that didn't come.
And then how will it be appropriated?
No. Hold on, please. You see, first, it is illegal, and let us not allow it to happen. Same way, there was a judgment stopping the police from participating in an election. And we are saying that no court, because the president of the Federal Republic of Nigeria swore to an oath to protect lives and property, no court can void that oath of office. It is in the implementation of that oath of office that he appointed an IG, the power that he has to protect life and property, that no court, because by tomorrow you will now see a court will stand up and say, we bar the Nigerian military, we bar the Nigerian police from 2027 election.
Okay.
It is an anarchy that we are going to create. And I'm saying that the judgment that came in yesterday is of bad faith.
Right.
Is using. How can you say?
He said
no,
see,
the truth is, this is my opinion here now.
Yes.
Is that money would first come to River State before the judge can say, I bar the governor from spending. It is not barring the. No, I'm coming.
Hold on.
It is not barring the source.
Hold on to that.
No.
Hold on. You will still continue.